Students, let's begin with lecture 6 of the practice series. Okay, these classes are sponsored by Sri Jendra Rank Zone. I'm your mentor, Shekhar Gehlot. Principle of natural justice is derived from the word just natural. Just natural. Of the Roman law, and it is closely related to the common law and moral principles but is not codified. It is a law of nature which is not derived from any statute or constitution. The principle of natural justice is adhered to by all the citizens of civilized state with supreme importance. Natural justice simply means to make a sensible and reasonable decision making procedure on a particular issue. Sometimes it doesn't matter what is the reasonable decision, but in the end, what matters is the procedure and who all are engaged in taking the reasonable decision. It is not restricted within the concept of fairness. It has different colors and shades which vary from context. Basically, natural justice contains three rules. Now, this is a introductory paragraph about what is natural justice. Okay, and what natural justice hinges upon. So, natural justice has three basic principles. Now, let us see each of them one by one. The first one is hearing rule, which states that the person or party who is affected by the decision made by the panel of expert members should be given a fair opportunity to express his point of view to defend himself. Secondly, bias rule. Bias rule generally expresses that panel of experts should be free from bias while taking the decision. The decision should be given in a free and fair manner, which can be fulfill the rule of natural justice. And thirdly, a reasoned decision, which states that order, decision, or judgment of the court given by the presiding authorities with a valid and reasoned ground. The principles of natural justice have been adopted and followed by the judiciary to protect public rights against the arbitrary decision by the administrative authority. One can easily see that the rule of natural justice, including the concept of fairness, they stay alive and support to safeguard the fair dealing. Okay, so now there are three type of rules which when combined together make one rule, that is called just natural or the natural justice. Natural justice means a justice which should happen in a natural circumstances. We do not require a written law for that. It is a natural part of justice. Okay, so hearing rule, one has to hear both the parties. Bias rule, one should not be biased. Okay, a judge cannot be a biased person. Then reasoned decision, whatever decision you deliver as a judge, you should give reasons for reaching to that conclusion. Okay, now these are the three rules in a brief. Now let us see what is the questions. Nemo judex and causa sol. Nemo judex and causa sua, or the principle that no one can be a judge in his own case, relates to which of the following rule of natural justice? Bias rule, reasoned decision rule, hearing rule, all of the above. Now, no one can be a judge in his own case. Now, suppose I have done something wrong and my father is the judge. Definitely, he'll be biased to me, isn't it? So, when he'll be biased, so for formal purposes, he may give hearing to the other party as well, and he may give reason decisions as well. But definitely, he was biased, and he will deliver a biased judgment and deliver reasons which are biased. Okay, so ultimately no one can be a judge in his own case. It has strictly to deal with the bias rule. Okay, so someone is judge in his own case, that person is going to have biasness in his own favor or in the favor of his related person. So our answer here is A, bias rule. Mr. X is a public servant employed in a PSU, and Mr. Y, who is the wife of Mr. X, is also an employee of the same public sector undertaking. Mr. A files a complaint against Mr. X for sexual harassment at the workplace before the ICC Internal Complaints Committee, which is headed by Mrs. Y. After completing her inquiry, she held that Mr. X is guilty and recommended disciplinary proceedings against him. Now, on what grounds Mr. X may challenge her findings? Now, husband wife both are working in a same company. Now, some female levels allegation against the husband that he has committed sexual harassment to me. Now, as per this procedure, an ICC, Internal Complaint Committee, will be set up to determine the charges. Now, this ICC comes to the conclusion that he is guilty, X is guilty. And who is heading this ICC committee? X is wife. Okay. So now it is surprising that wife has now found husband guilty. Okay, so from visible eyes, it may not appear that there was any bias. Okay, because we may feel that she has held her husband guilty, so there was no biasness. But yes, there can be a biasness in this case as well. Husband and wife may not be on the good terms. So now, on what grounds X may challenge her findings? Mrs. Y is an employee of the same institution, and the inquiry should have been conducted by a person outside the institution. Now, this is against the rules of the ICC. Internal Complaints Committee should be headed by internal person only, so this cannot be a rule. The complaint filed by female employee, so the inquiry must have been conducted by a male employee. This is also goes against the rule of Internal Complaints Committee. Okay, in order to prevent any fear coming into the minds of a female employee, ICC is usually headed by a female only. Mrs. Y is the wife of Mr. X, and she holds a personal bias in the case, so the inquiry should not have been conducted by her. Now, this goes against the rule of principle of natural justice, that no one should be a judge in his own case. Okay, so now a wife cannot judge her husband. Okay, either way she may deliver a biased opinion. If she is acquitting him, then also she will be biased. If she is finding him guilty, then also she will be biased. So this is our perfect answer. Now let's look at the option D. Mr. X, being the accused, should have conducted the inquiry himself. Obviously we cannot allow the accused to conduct his own investigation, so in this case our answer is going to be answer C. Mr. A is a judge and he is also the landlord of Mr. B, who resides in an apartment owned by Mr. A. So Mr. A is a judge and he is also a landlord of Mr. B. So Mr. B resides in Mr. A's apartment. Okay. Due to non-payment of rent for 3 consecutive months, Mr. B has not paid the rent for 3 consecutive months. Mr. A served an eviction notice to Mr. B. Now choose the most appropriate option amongst the following. Now Mr. A, who is a judge, he sent an eviction notice to B. Now let us see what are the options. Being a judge himself, Mr. A cannot issue such a notice of eviction. Mr. A can issue such notice because it is his duty as a judge apart from being a landlord. Such notice is illegal as Mr. B was not given an opportunity to present his case. Mr. A issued notice in his personal capacity as a landlord and not being a judge. Now you have to understand Mr. A is a landlord as well here. Okay, so when Mr. A is landlord and Mr. B is a tenant who is not paying, so landlord has a right to issue a notice to the tenant to evict the premises. Now Mr. A, he may be a judge, but he does not give up his right of being a landlord. He is a landlord as well. So when Mr. B will not pay to the landlord is Mr. A. Who is authorized to issue a notice? Landlord only, Mr. A only will issue a notice, isn't it? Nobody else can issue a notice. Only a landlord is entitled to issue a notice. Landlord here is Mr. A. So when he issues a notice, he is not issuing a notice in the capacity of a judge. He is issuing the notice in the capacity of a landlord. So in this case, though it may appear that there is a bias, but there is no bias. Okay, there is no biasness here. Okay, and plus he has only served a notice. Okay, this notice we can serve anytime to anyone. Okay, so notice is not a not a legal proceeding. Okay, so the bias rule applies only in the legal proceedings or administrative proceedings. Sending a notice is neither a legal proceeding nor a administrative proceeding. So Mr. A issued such notice in his personal capacity as a landlord and not being a judge appears to be a sound answer here. Which of the following is not in violation of principle of natural justice? Withholding an increment of a public servant without giving him an opportunity to defend. Non-renewal of a contract of employment of an employee after a period of contract is over. Initiating a departmental inquiry against a public servant without giving him an opportunity to submit representation during such inquiry. All of the above. Now, you read the question again. Which of the following is not in violation of a principle of natural justice? Don't be in a hurry and read it like which of the following is a violation of principle of natural justice. Okay. So if you'll read it like this, all of the above may appear to be a correct answer to you. But if you'll read the question properly, which of the following is not? So if we look at the option A, withholding of an increment of public servant without giving him an opportunity to defend, this is definitely a violation of principle of natural justice. But here we are talking about what is not violation. So it is a violation, so it goes out of our option. Initiating a department inquiry against a public servant without giving him an opportunity to submit representation. So if you do not allow someone to represent his case, definitely principles of natural justice are violated. So this also goes out of our options. When one option goes out, this option, all of the above automatically goes out. So now we are left with only one option, that is non-renewal of a contract of employment of an employee after the period of contract is over. There is nothing wrong here, okay? Once the period of contract is over, contract is complete, concluded. Now entering into a fresh contract depends upon the will of both the parties. One party cannot say that other party is bound to renew my contract. There is nothing like that, okay? So this is not a violation of principles of natural justice. On the basis of your understanding about natural justice in the passage above, state which of the following is true. Adherence to the reasoned decision rule is not required if other two rules are complied with. Compliance of bias rule itself rejects the need of the hearing and reasoned decision rule. Principles of natural justice is incomplete without the compliance of any of its rules. The reasoned decision rule is substitute of the bias rule. Now if you see, there are three principles and all three are equally important. You cannot say one is important. If two are followed, you may not follow the third one, or one of them is so important that if you follow that one, you can substitute the other two. No, all three principles are equally important. Okay, so adherence to the reasoned decision rule is not required if other two rules are complied with. So even if one rule is not followed, principle of natural justice shall be violated. So this is not true. Okay, compliance of bias rule itself rejects the need of the hearing and reasoned decision rule. This is also not correct. Okay, because if you comply with the bias rule, that means you are not biased. That doesn't mean you will not give opportunity of hearing to the party and you will not give reasons for your decision. Okay, so this is also not true. Principles of natural justice is incomplete without the compliance of any of its rule. Now this is the only ultimate answer, because principle of natural justice will remain incomplete without compliance of any of its rule. You have to comply with all the rules. You cannot leave even a single rule away. So our answer is answer C.
It's 2 o'clock.
Tension prevailed in the Jawahar area in the Palghar district after three Mumbai residents traveling in the Ford EcoSport to Silvassa were allegedly lynched late on the Thursday night. The Kasa police station said the incident occurred near Gadchiroli, Gadchiroli village, Gadka Chinchale village under their jurisdiction. Information received by us indicates that the three occupants of the SUV hailed from Kandivali in Mumbai and were going to attend a funeral in Silvassa. Superintendent of Police Gaurav Singh Palghar Police said Superintendent of Police Gaurav Singh, Palghar Police said. A large mob of villagers surrounded the car within a matter of minutes and started attacking it with the sticks, iron rods, and their bare hands, leading to the death of the three occupants. One of our patrolling vehicle later spotted the severely injured trio lying on the road and stopped to find out the matter. However, our team was also attacked by the mob and the vehicle pelted with the stones. Our personnel had to flee and were unable to rescue the victims, an officer of the Kasa police station said. A wireless alert was sent out later, apprising all police stations and units of the incident, following which reinforcements were sent to the village and a combing operation was undertaken. Prima facie, information indicates that the trio were mistaken for thieves and attacked. The villagers were on edge due to the ongoing lockdown and unavailability of the essential supplies. For the past few days, several rumors have been doing rounds on the social media about thieves and dacoits targeting villages on their highway. On the highway. As a result, villagers have been patrolling the highways and stopping late night travelers on suspicion, the officer said. Which of the following statements given below justifies criminalization of mob lynching? Now you all understand what is mob lynching. Mob means when more than around 10-20 people come together and they kill someone. Lynching means killing. They will kill someone, they beat someone so badly that he is dead. So that is called mob lynching. Okay, organized killing of people by a lot of crowd. So which of the following statement justifies criminalization of mob lynching? In a democracy, the actual power rests with the people and their actions cannot be penalized by the state. And yes, in the democracy, actual power lies with the people, but it is not true to say that their actions cannot be penalized by the state. We are a part of the state. There is no law in India which specifically prohibits mob lynching, and therefore it is justified act of the people. Uh, Let us assume there is no law for mob lynching, but definitely lynching itself is not allowed. It is not justified. Killing someone is not justified. We have a law that you should not kill someone, either in mob or singly. So this is also not a good option. It is impossible to punish the wrongdoer in case of mob lynching. It may be difficult, but it cannot be said to be impossible. So it is also not a good option. We are left with only option D. We do not even need to check it. Probably we have got our answer. Let's read option D. Violence cannot be a tool to implement the will of the majority, and such actions are failure of state. Okay. On this basis, definitely violence cannot be a tool to implement the will of the majority. People cannot come to violence in order to satisfy their urges, and such actions are failure of the state, and thus we have to have a criminalization of mob lynching. The option D appears to be sound, so our answer is option D. Which of the following statement justifies the criminalization of mob lynching as a distinct offense apart from murder? The offense of murder is committed by a single individual or a group, but mob lynching involves a large group of individuals. Uh, so now the question is, how do you justify making two categories? One is mob lynching and one is murder. Okay, in mob lynching also a person is killed, murder also a person is killed. How do you differentiate between these two? Let us see what are the options for differentiation. The offense of murder is committed by a single individual or a group, but mob lynching involves a large group of individuals. Yes, this can be a basis of differentiation. When violence is committed by a mob, it creates a situation of terror and anarchy having potential to disturb the public peace for a longer period. Yes, it does happen. Mob lynching is an offense which supports the idea of might is right and cannot be accepted in a democratic society. Yes, we can accept this in the democratic society. All options appear correct. So we'll go with the option D that says all of the above. All these reasonings can be used in order to differentiate murder from mob lynching. The above passage states that the existence of rumors in the area regarding the thieves and dacoits robbing the villagers or committing child lifting. In the light of this proposition, which is the which of the following statement is correct? It should be of, not if. The villagers should not be punished as there was a genuine mistake on their part. The villagers should be punished as they do not have any right to punish any person unless he is an offender. So can we go with option A? The villagers should not be punished as there was a genuine mistake on their part. See, we cannot call it a genuine mistake. Okay, there may be a mistake. They could have arrested them. They could have taken them to police station. But killing someone will take up all the benefits of a genuine mistake from the offender. So definitely this option we cannot go with. The villagers should be punished as they do not have any right to punish any person unless he is an offender. Yes, villagers do not have any right to punish anyone. This statement is correct. But now they go further unless he is an offender. See, even if someone is an offender, declared offender, then also no one has a right to punish anyone. It is only state's job. Law and order will take care of it. Okay, we have a courts, we have a system of judiciary, they will take care of it. You can only do the best is you can hold the person, or you can just simply arrest the person and hand him over to the police. Not more than that. You cannot hurt him. The villagers should be punished as no individual in the country is entitled to take law in his own hands and punish the wrongdoer. Okay, this option is very appropriate, but let's read D as well. The villagers should not be punished. The moment it says villagers should not be punished, I do not read it. I do not need to read it more. So we have option C, which appears as a correct answer here. In the light of the above passage, which of the following incidents of mob violence would be justified? A group of people committing violence against people who are selling meat. Let me read it again. In the light of the above passage, which of the following incident of mob violence would be justified? So, which of the following violence of incident of mob violence would be justified? So, this should ring a bell into your ears that they are trying to justify a mob violence, which is not a justifiable act. So, we are not going to have many options. Let us see if we have none of the above option. Yes, but let us first read. A group of people committing violence against people who are selling meat of an animal considered to be sacred under the religious belief. Even if someone is carrying a cow meat, you cannot kill or beat or do anything wrong with that person. You can only report to the police. So this option cannot justify mob lynching. The residents of a boys' hostel caught a drug peddler selling drugs in their hostel and killed him by beating. Yes, he may be selling drugs and that is a banned activity, but still you cannot kill someone. The villagers injured a woman by pelting stone at her, considering her to be a witch. Uh, I don't know how villagers consider women as a witch, but they cannot do so, and they cannot pelt stone as well. So none of the above, so none of the statement justifies mob lynching. It's an offense and should be treated like that. So we'll go with answer T here. Assertion A. Mob lynching can be justified only in circumstances where the religious sentiments or feelings of a large group of people is associated. Religious sentiments and feelings are of paramount consideration for the state and should not be interfered with. Now let us see what is it. Assertion A. Mob lynching can be justified only in circumstances where religious sentiments of large people is associated. See, we cannot justify mob lynching in any case. Forget about religious feelings or a large group of people. Okay, so statement A, assertion A becomes wrong here. Let's proceed to reason B. Religious sentiments and feelings are of paramount consideration for the state and should not be interfered with. Yes, religious feelings are paramount consideration, but should not be interfered with is a too far-fetched statement, so this statement automatically becomes wrong. So now let us see what are our options. Both A and R are correct. No, both are incorrect. A is correct, R is incorrect. A and R are incorrect. A is incorrect, but R is correct. Mm, So we'll go with option C here. However, if this question was only till this level, if this highlighted portion was not there, religious sentiments and feelings are of paramount consideration for the state, and state should take care of it. then we would have gone with option D. A is correct, A is incorrect, R is correct. But they are saying should not be interfered with. That is too far fetched. Common intention implies a pre-arranged plan and acting in concert pursuant to the plan. Common intention comes into being prior to the commission of the act, which need not be a long gap. To bring common intention into effect, a pre-concert is not necessarily be proved, but it may well develop on the spot as between a number of persons and could be inferred from facts and circumstances of each case. So common intention can be developed at the spot as well. When we are discussing about the case of common intention, usually people join each other with a pre-planned conspiracy, but it may not be the case every time. Okay, common intention may be developed just at the spot within a matter of few seconds as well. Okay, for example, A and B caught hold of C where only B stabbed C with a knife, but A is also liable to the murder, as there was a pre-concerted action. In such case, in the case Pandurang versus State of Hyderabad, Supreme Court emphasized on this point that prior concert need not be something always very much prior to the incident, but could well be something that may develop on the spot on the spur of the moment. Now, common intention versus similar intention. Common intention does not mean similar intention of several persons. To constitute common intention, it is necessary that intention of each one of them be known to the rest of them and shared by them. Okay, so it is not that everyone should have a similar intention. Like we have A, B, C, D. It is not that whatever A wants, B also want that, C also want that, D also want that. Okay, this will become a similar intention. But if we talk about common intention is A want to do something, B, C, D, E they join him because they are friends of A or they believe in the cause of A. Now, though the intention is of A, but B, C, D join in the conquest of A. So now this is called a common intention. That intention has become a common. One person had it, other people follow it. Similar intention means all four people individually also hold similar intention and they also have same grievance. So can you understand? In the case of Dukhmosh and Pandey versus State of Bihar, the Supreme Court held that common intention which developed at the spur of the moment is different from the similar intention actuated by a number of persons at the same time. The distinction between a common intention and similar intention may be fine, but is nonetheless a real one and if overlooked may lead to miscarriage of justice. The mere presence of accused together is not sufficient to hold that they shared the common intention to commit the offense in question. It is necessary that intention of each one of several persons be known to each other for constituting common offense. So now what is key point here for common intention? Key point is that everyone should know about the intention of each other for constituting a common intention. A wants to do something, B wants to support E. B knows what A wants and B supports A. C knows what A wants and C knows what B wants as well and he wants to support B and A. D knows what A wants, B wants and C wants and what they are doing and I will help them. So this is a kind of common intention, okay? That everyone should know each other's intention. A gang of six members went to a bank, armed with weapons to commit a heist. While five of the gang members went inside the bank, Mr. A, the sixth member, waited outside the bank to alert them on any threat. During the heist, one of the gang members fired a gun at the branch manager. As a result, he died. All five escaped, but Mr. A was caught and arrested. Now choose the most appropriate option as per the principle stated in the above passage. Mr. A is not liable for murder as he was outside the bank and there was no common intention. Okay, Mr. A is not liable for murder as he was outside the bank and there was no common intention. Mr. A, along with all the other members of the gang, are liable for the murder as there was a common intention. Only that person is liable for the murder who actually fired the gun. Mr. A is liable only for the heist and no other offense. Now, it may be a case that Mr. A could have been uh, liable only for heist but no other offense. But if we look at the facts of this case, a gang of six members went to a bank armed with weapons to commit a heist. Now they are armed with weapons. That means they were ready for any contingency. That if case If need be, we'll shoot as well. So they are sharing a common intention, and in that common intention, some crime is committed. All should shoulder the burden of that crime, though one of them committed it. Mr. A, along with all the members of the gang, are liable for murder as there was a common intention, appears to be a just answer. Raman and Raghav were riding on a motorcycle on a busy street. Suddenly, Aman, another biker, bumped into their bike. A heated argument started between the three of them. While Raghav started abusing Aman, Raman hit Aman with an iron rod lying on the road, and as a consequence, he died. Now choose the correct option. Both Raman and Raghav are liable for the murder as there was a common intention developed on the spot. Raghav is not liable for the murder as there was no common intention to kill Aman. No one is liable as Aman was wrongdoer himself and he started the fight. Only Raghav is liable for murder as he started abusing Aman. Now, in this case, see the facts of the situation are that two people are on one bike, one people on a separate bike. They all collide and then they start fighting. This is road rage. Typically, it happens every day, in different places. So it's a very common thing, unfortunately. So what happened? People do abuse each other. So Aman and Raman are abusing each other. Aman and Raghav are abusing each other. Meanwhile, Raman hit Aman with an iron rod. Now, if Raman was carrying this iron rod with himself, we could have expected that they were having a common intention to beat anyone who comes in our way. But iron rod was lying on the road. It was lying somewhere. Raman saw it. Raman hit it with Aman. Raghav never knew, or they were not having any such intention, common intention. Raghav did not know that Raman would pick the iron rod and hit the Aman. It is a shocking incident even for the Raghav. So in such cases, we cannot say Raghav and Raman both are having a common intention because this is happening on the spur of the moment and nobody expected this to happen. So Raghav is not liable for the murder as there was no common intention to kill Aman. It is not the case that Raghav held the hands of the Aman so that Raman could hit him, or Raghav did something in order to assist Aman, or Raghav took the rod from the street and gave it to Raman. Nothing is happening. Raghav is just abusing. Suddenly, Raman came out of nowhere with a rod and hit him. Now, how could Raghav be made liable for that? Okay, so this is not a case of common intention. We have to understand the law clearly. Otherwise, we are going to do more injustice than justice. Okay, we cannot keep putting innocent peoples behind the bars and we cannot let criminals set free as well. After reading the passage, which of the following is not correct in relation to the difference between common and similar intention? Similar intention is developed prior to the commission of the offense, but the common intention is developed only at the time of the commission of the offense, which is not correct. Okay. Under a common intention, each of the offender is equally liable for the offense, but under similar intention, each of the offender is differently liable. In order to determine the existence of similar and common intention, one must analyze the fact. The boundary between the similar and common intention is very fine and it may some overlap. Yes, it is correct. This is correct. Now let us discuss these two. Under common intention, each of the offenders is equally liable for the offense, but under similar intention, each of the offender is differently liable. Yes, here each of the offender is differently liable, and let us see what is not correct. Then only option left is similar intention is developed prior to the commission of offense, but the common intention is developed only at the time of commission of the offense. No, common intention can be developed even prior to the commission of offense. So this is not correct. So we'll go with on. Our answer is option A. Mr. X and Mr. Y entered into a house at night to commit theft. While committing theft, Mr. Y committed sexual assault on a minor girl aged 11 years. Identify for which of the following offenses Mr. X is liable. Both theft and sexual assault as there was a common intention. Only theft as there was a similar intention. Only theft at Mr. X had a different intention from Y. He would not be liable for any offense. So definitely he has committed theft. We cannot say he would not be liable for any offense. So this goes out of the picture. But now let us see whether what they tried to do. They entered in the house in order to commit theft. They did not have a common intention or any intention at all to commit a sexual assault on a girl, that to a minor girl. So somehow what happened, I don't know, to Mr. Y, he committed it. Okay. But Mr. X did not do it. So Mr. X cannot be liable for sexual act of Mr. Y because he was not having a common intention with Mr. Y. And if the facts would have specified that when he was committing the sexual assault, Mr. X was watching at the door or something like this, then also we could have inferred that there was a common intention. But plain reading, it simply says that the common intention was to commit theft only, but while committing theft, Mr. Y also ended up in committing another crime for which they had no agreement at all. So only Mr. Y will be punishable for this act, and Mr. X will be guilty for only theft as Mr. X had a different intention from Y. So option C appears to be the correct option here. Which of the following statements is correct in relation to the difference between common intention and a similar intention? The intention of the accused and co-accused can be inferred from the facts and circumstances of each case. Under the common intention, it is considered that all the accused have jointly committed the offense themselves and are jointly liable. Each accused is liable for the offense he has actually committed if the common intention cannot be proved. Now, all of the above. Okay, now all of the above because all statements are correct. So, our answer is all of the above. In similar intention, every person is liable as per the role he played. Okay, like in this case, they had a similar intention to commit theft, so they are all liable for their roles. He is liable only for theft, he is liable for theft as well as for sexual assault. In common intention, if there was a common intention to do anything, whatever happened, then they both would have been liable. Article 21 of the Constitution of India prohibits ex post facto laws. We discussed ex post facto laws. The expression ex post facto law means a law which imposes penalties or convictions on acts already done and increases the penalty for such acts. In other words, ex post facto law imposes penalties retrospectively. Like tomorrow I did something previous year. Now today they bring a law and say that even someone has done this previous year, he'll also be guilty for that. So that is not allowed in the Constitution of India. So this is called ex post facto law. Imposes penalties retrospectively. For example, the Dowry Prohibition Act 1961 came into force from 25 1961. A person guilty of accepting dowry is punishable under Act after 25 1961 and not before 25 1961. So all the cases of dowry before 25 1961 go unchallenged and unnoticed, but at least we have some Act 1961. Better late than never. Acts post facto laws are of three kinds as follows. Sorry. A law which was declared some act or omission as an offense for the first time after completion of that act or commission. Okay, some law became for the first time a law has been brought up just like dowry. A law which enhances the punishment or penalty for an offense subsequent to the commission of that offense. A law is already there, but later on somehow punishment is enhanced. This is the second type of ex post facto law. A law which prescribes a new and a different procedure for prosecution of an offense subsequent to the commission of that offense, or a law which provides a different kind of procedure for trying that particular accused. Clause 1 of Article 20 provides protection only in respect of the above first two categories of the ex post facto laws. Article 20 provides protection only in cases of Clause A and Clause B, but it does not protect you in Clause C. Okay, laws which declare acts as offences subsequent to the commissions to those acts, and laws which enhance the penalties subsequently. They are prohibited. Article 21 provides no person shall be convicted of any offence except for violation of law in the force at time of the commission of the act charged as an offence, nor be subjected to a penalty greater than that which might have been inflicted under the law in force at the time of the commission of the offence. The first part of the clause 1 provides that no person shall be convicted of an offence except for violation of the law in the force at the time of the commission of the act charged as an offence. The second part of the clause 1 protects a person from penalty greater than what which he might have been subjected to at the time of the commission of the offense. Okay, now this is the explanation of clause 1 and clause 2. Clause 1 and clause 2 means clause A and clause B, which are explained here. The Parliament of India legislated The Parliament of India legislated the Sexual Harassment at Workplace Act in year 2013, and simultaneously some new offences were also added to the Indian Penal Code 1860. Mr. A is an employee of an institution against whom departmental inquiry has been initiated for committing sexual harassment for a female colleague in year 2012. Now choose the correct answer. Such inquiry is valid as per Article 21 of the Constitution, and the complaint was made after the Act came into force. Article 21 will not be applicable. So such inquiry is valid. Yes, inquiry is valid, no issues. Article 21 will not be applicable as the matter does not relate to an offense. Yes, it is actually an offense. So Article 21 will be applicable here. Not a good option. As the act was passed in year 2013, any inquiry under such act is invalid. Yes, this is also inquiry can be conducted in this case, but every inquiry will become invalid. That is not digestible. Only inquiry may be conducted, but no penal action can be taken against him after such inquiry. Yeah, this is the import of no ex post facto. You may conduct an inquiry. There is no problem over conducting an inquiry, but you cannot find someone guilty. You cannot give punishment to someone when he has done something before the coming of the law. So we'll go with option D here in this case. Article 21 would not affect which of the following acts of the legislature: Act of the legislature enhancing the term of imprisonment, Act of the legislature enhancing the amount of fine, Act of the legislature changing the punishment of death to life imprisonment, Act of legislature changing the nature of imprisonment from simple to rigorous. Now, let us see. Let us see what are our options. Article 21 would not affect which of the following: Act of legislature enhancing the term of imprisonment. Imprisonment is enhanced after the commission of the act, not allowed. Act of the legislature enhancing the amount of fine. Amount of fine is enhanced after committing of the act, not allowed. Act of legislature changing the punishment of death to life imprisonment. Changing of punishment, is it allowed? Let us see. A law which is declared some act or omission as an off act for first time after completion of the act, okay, not allowed. A law which enhances the punishment. Which enhances the punishment. Now let us see which option is there. Act of legislature changing the punishment of death to life imprisonment. So they are here not enhancing the punishment, they are bringing the punishment down. So that means this will not be hit by the bar of Article 21, and this will be a valid exercise. Article 21 would not affect this. Act of legislature changing the nature of imprisonment from simple to rigorous, that is an enhancement. So our option is option C here. Mr. A is a student of law, aged 19 years. He is socially active and expresses his opinion on every social and political event of the nation through social media platforms. In one of his blogs, he severely criticized the policy of a state government. of changing names of cities and towns. He also stated that the government is biased towards a particular religion. The said blog, just a second please. Mr. A is a student of law, aged 19 years. He is socially active and expresses his opinion on every social and political event of the nation through social media platforms. In one of his blogs, he severely criticized the policy of a state government of changing names of cities and towns. He also stated that the government is biased towards a particular religion. The said blog was posted on 19th April 2020 and subsequently an amendment was made to Indian Penal Code whereby hate speech was made a distinct offence and punishment was prescribed. Okay, so he posted the blog on 19th April 2020 and subsequently law was brought up. An action was brought against him under the said provision for the blog. Now choose the most appropriate option against the following. Mr. A may be liable for the offence of hate speech as the blog was not removed even after the amendment. Mr. A may be liable for the offence of hate speech as Article 21 does not cover such areas. Mr. Article 21 covers such areas as well, so this is not a correct option. Mr. A may not be liable for the offence because the act was done before the amendment. Yes, this is also true. Mr. A may not be liable for the offence as his blog was innocent and fair criticism. We are not going into that thing right now. Uh, so we'll not consider it. So now he posted the blog on 19th April 2020. It nowhere says that he has removed the blog, so that means blog still stays there. So if he has not removed the blog even after coming of the amendment, now every day when his blog appears there, it amounts to a offense. So Mr. A may be liable for the offense of hate speech as the blog was not removed even after the amendment. So if he would have removed the amendment, if he would have removed the blog before amendment, then A may not have A may not be liable for offense because act was done before the amendment. This would have been correct option. But since it does not say anything about removing the blog, they say the blog was posted and that means blog is still posted. So our answer is A. So though he should not have been liable if he would have removed it before the amendment or even after coming the amendment anytime, but he has continued to stick with his blog, so now his blog cannot take the immunity of section article 20. Considering the fact situations given in the avocation, the parliament passes a legislation in September 2020 whereby an amendment is made to the juvenile act and now a person below the age of 20 would be a juvenile and a special procedure would be followed for his trial. Choose the most appropriate option amongst them. So in September 2020, a legislation change is made in the juvenile justice and he posted the blog on 19th April 2020. That means when he posted the blog, he was not a juvenile. Okay, he was about 18 years of age. He was not a juvenile, means someone who's below 18. So he was an adult. But later on, an amendment in September 2020, after he has committed his crime, act is passed where people below 20 would be treated in a different manner. So let us see. Mr. A would not be considered as a juvenile as it is prohibited under the scheme of Article 21. Mr. A would not be considered as a juvenile because the amendment came after he committed the offence. Mr. A would be considered a juvenile and tried under the new procedure. None of the above. Now, 157, we have to go back to the principles again. There are three principles. A law which declares some act or omission as an offence for the first time after completion of the act. This is, we are not discussing here. A law which enhances the punishment or penalty for the offence. No punishment is enhanced here. A law which prescribes a new and different procedure for the prosecution of an offence subsequent to the commission of that offence. Now, this is the principle applicable. A no law which prescribes a new and different procedure. Now, a different procedure is set for Mr. A. Now, Mr. A will be treated as a juvenile and tried as a juvenile. Now, protection is available only with respect to first two categories. That means there is no protection here. So, Our answer here should be Mr. A would be considered a juvenile and tried under the new procedure because this falls in the clause C of the 21A, and only clause A and B are protected, not C. So our answer is C here. Considering the fact situation in the third question to this passage, the Parliament passes a legislation for the probation of offenders, under which any offender below the age of 21 will not serve the sentence of imprisonment in a person. Instead, he will serve the sentence in a probation house. Now choose the most appropriate answer. Mr. A will get the benefit of the Probation of Offenders Act. Mr. A will not get the benefit of the Probation of Offenders Act as it is prohibited by 21. It is discretion of Mr. A to decide. You cannot decide what sentence has to be given to you, so this is out of the option. None of the above is out of the option. Mr. A will not get the benefit. So when we talk about benefit, subsequently benefit can be given. We discussed in the previous question. Enhancement, something which goes against you, cannot be put on you, but some benefit can be conferred to you. So Mr. A will get the benefit of Probation of Offenders Act. Principle: nothing is an offense if it is done under intoxication and the person committing the offense was incapable to understand the nature of the act. Intoxication should be without knowledge and against the will of the person. A, B, and C were having a party in a bar where A persuaded B and C to take alcoholic drinks. On the persistent persuasion, B and C also consumed alcohol along with A. B and C had never consumed alcohol before, but A led them to drink alcohol after intoxication. So after intoxication, there was some argument between B and C, though both are new drinkers, where C pushed B with full force, causing serious injury to B. Now let us choose the correct answer. C is liable because he has thrown the B with force, but he was under intoxication led by A. C is not liable because he was intoxicated, maybe. A is liable because A persuaded them to consume alcohol, whereas they had never consumed alcohol. A is not committed the crime. A and C both are liable. So now let us go back to the principle. Principle says nothing is an offense if it is done under the intoxication, and the person committing the offense was incapable to understand the nature of the act. Intoxication should be without knowledge or against the will. Now, in this case, A persuaded B and C and they gave up to the persuasion and took the alcohol. But is there any case where it states that A deceitfully provided them drink without their knowledge, or A against their will poured drink in their mouth? It is not such. He persuaded, they agreed, so that means C is liable. C is liable here. Everyone has the right to private defense to defend his body and property by use of reasonable force, unless that person had time to have recourse to protection of public authorities. Okay. X receives information at 5 p.m. that Y, along with few friends, is planning to burn his crop at midnight, which is ready to be harvested. He does not inform the village police station, private defense we are talking, which was just 1 kilometer away. He gathers his family members and directs them to collect some weapons in the form of swords and lathis to protect his field crop. At around 11 p.m., Y and his aides attack the crop, and severe fight ensues between and wherein Y is seriously injured. Now let us see. X is not liable as he was exercising his right to private defense. So Y is trying to burn down his crops. Okay, so he is trying to protect, exercising his right of private defense. Maybe X and his family members are not liable for the injuries caused as they were exercising the right of private defense. Only X is liable. X and his family members are liable as they have not informed the police. Now, this is a key aspect here. He received the information at 5 p.m. that around 11 p.m. they are going to do something. There is a gap of good 6 hours, and police station is just 1 kilometer away. He did not inform police. What he did, he himself collected weapons and arms in order to take revenge. Now, this is a revenge seeking attitude. This is not a private defense. So, this is not protected, okay? Because the principle also says everyone has the right of private defense to defend his body and property by use of reasonable force, unless that person had time to have recourse to protection of public authorities. So, he had sufficient time. So, here, X and his family members are liable as they have not informed the police. Doing an act which causes common injury, danger, or annoyance to public, or which is likely to cause such injury or annoyance to public, is nuisance. A common nuisance is not excused because it causes some nuisance or advantage. A common nuisance cannot be excused because it causes a little nuisance, they mean to say, or it causes some advantage to the person who's committing the nuisance, that it had some advantage for me. A farmer having a large farmlands burn crops residue stubble on his fields after harvesting the crop to make the field ready for the next crop, as this is easy, fast, and convenient method of making the field ready for the next crop. His farmlands are adjoining a densely inhabited residential area, and the people pass through the smoke while traveling on the road adjoining in his farmlands. The smoke caused by a fire also enters the houses in the colony. A has not committed any offense since he does not cause any specific injury to any specific person. No, it is an environmental pollution. So we have to find option which says A has committed offense. All option C is not committed, only one says A has committed public nuisance. So we'll go with option C because yes, though we sympathize with the farmers and their plight, but whatever is the law is there. Okay. 162. Whoever causes death by rash or negligent act commits an offense. X is having a house on the roadside which is also having a street on the back of the house. He has a lawn on the back of his house where he has built a toilet. To prevent the intruders from entering his house, he got the fence charged with a high voltage live electric wire. Z was passing through the street at the backyard of the house of X and sat down to take rest near the fence. While getting up, his hands came in contact with the fence, which was connected to high voltage electric wire, causing his death. Now, I don't think we need to get into much options here. He has definitely committed an offense. But let us see which offense he has committed. X has committed an offense of causing death by rash and negligent act. X has committed no offense. X has committed no offense of murder. So has he? Definitely, a person has died here, but it is not that he planned to kill this person. So it is not a murder. But yes, his act was so rash and negligent that it led to death of some person. So we'll go with option B. X has committed an offense of causing death by rash and negligent act. Killing is not a murder if it is committed in a sudden fight without premeditation, in a heat of passion, and upon a sudden quarrel. Okay, so killing will not be a murder if it is committed in a sudden fight without premeditation, in a heat of passion, and of sudden quarrel. X and Y were buying liquor from liquor shop at 7 p.m. Y abused X, and there was a quarrel between X and Y that he will not spare him. And Y shouted that his house is adjoining the shop only, and if X had the guts, he can come anytime. X went back to his shop, which was nearby, procured a knife, and went to Y's residence at 9 p.m. and stabbed him to death. Now let us see what he has done. X has committed murder. Let us see. X has not committed an offense of murder since it was committed in a sudden fight. X has not committed a murder of Y because he had no enmity with Y. Definitely he had enmity. X has committed no offense, goes out of the picture. So X has committed no offense since it was committed in a sudden fight. Now let us see whether it was a sudden fight or not. See, sudden fight. X told Y that he will not spare him. Y, X went back to his shop, which was nearby, procured a knife. So, this action of going back and coming back with a knife and stabbing it says a lot of planning, and it throws all the notion of sudden fight out of the window. So, we have only one option, that is X has committed murder. Use of criminal force intentionally, knowing that it would cause or is likely to cause injury or annoyance to the person against whom force is used, is an offense. X, a renowned social worker who had launched a movement for liberalization of women, pulls up a Muslim woman's wheel in public in good faith without her consent. causing annoyance to her. Okay. X is a renowned social worker and he has committed no offense because his motive was good. X acted in good faith to liberate her from the clutches of tradition and has hence committed no offense. X has done the act in public and not in secrecy, therefore had not committed any offense. X has committed an offense by use of criminal force. So the principle simply says use of criminal force intentionally knowing that it would cause or is likely to cause injury or annoyance to that person. So he may be a social worker, okay, but nobody gives him a right to do what he has done. A right to pull up a Muslim woman's wheel in public, okay, without her consent, causing annoyance to her. So definitely X has committed an offense by use of criminal force. So we'll go with option D. Master is liable for the acts of his servant done in the course of his duties. X hired an employee Y in his construction business. Y was the property in charge who received construction material and K receipts for the material received by him. Z claimed payment for cement supplied to X, which was duly received by Y. X denied the payment on the ground that he has only received half of the material and the balance was misutilized by the employer. Balance was misutilized by employer. X is liable for the entire amount. X is liable for the part amount only for part of the cost of half of the material. X is not liable for the misconduct embezzlement of his employee. X can claim the balance payment from Y only. So X is liable for the embezzlement of his employee. So therefore X is liable for the entire amount. And yes, later on, yes, X is liable for the entire amount because he was in the course of his employment when he received the money from the person. Where one of the parties to contract was in position to dominate the decision of other party. The contract is enforceable only at the option of the party who was in position to dominate decision of other party. Doctor asked his patient to make a payment of 10 lakh rupees for treatment of his fever, coronavirus probably. The patient paid an amount of 5 lakh only and promised to pay the remaining amount after the treatment. After treatment, the patient recovered from fear. The doctor demanded the remaining amount from the patient. The patient refused to pay. The contract is enforced against the doctor. The contract is enforceable against the patient. The contract is not enforceable. The contract is not enforceable against the patient. So our answer here is definitely B. Contract is enforceable against the patient. When at the desire of one person, any other person has done or abstained from doing something, such act or abstinence or promise is called a consideration for promise. X, the uncle of Y, made a promise to pay him an amount of 1 lakh rupees as a reward if Y quit smoking and drinking within a year. Y quit smoking and drinking within 6 months. Now let us see. Consideration has moved from the side of X. Consideration has moved from the side of Y. Consideration has moved from the side of Y. Quitting smoking and drinking cannot be a consideration. Now we are not going into this hypothetical situation. Okay. We'll just remain with the fact and the principle. When at the desire of one person, when at the desire of X, another person has done, X has done or abstained from quitting and smoking, such act or abstinence is or promise is called a consideration. So in this case, consideration has moved from the side of Y because he is the one who has quit smoking and drinking for 1 lakh rupees. Good choice. A man is guilty of not only for what he actually does, but also for the consequences of his doing. A wanted to kill the animal of B, but he saw B standing with his animal and fired a gunshot at the animal. The gunshot killed B. The gunshot killed B. A is guilty of killing B. A is not guilty of killing B. B is guilty of standing with the animal. Can be guilty of standing with the animal? This cannot be an option. A did not know the gunshot will kill B. Yes, he did not know it, but definitely he should have taken precaution because animal is standing with the person, so person will also get killed. So A is guilty of killing B here, though maybe unintentionally, but yes, he has done that. He should have taken enough precaution. When a party to a contract has refused to perform or is disabled or has disabled himself from performing his promise in its entirety, the other party shall not put an end to the contract. When a party to contract has refused to perform or disabled himself from performing his promise in its entirety, the other party shall not put an end to the contract. Okay. A engaged B on April 12 to enter his services on June 1, but on May 11, A wrote to B that his services would not be needed. On May 22, B joined C for employment. A cannot put the contract to an end. B can put the contract to an end. C can put the contract with B to an end. A must pay damages to B. Now let us see what is the principle again. When a party to contract has refused to perform or disabled himself from performing his promise in its entirety, the other party shall not put an end to the contract. The other party shall not put an end to the contract. Now A engaged B on April 12 to enter his services on June 1. But May A wrote to B that his services would not be needed. Okay, that means A has terminated the contract of B. Now B definitely cannot put an end to the contract because contract is already terminated by him. Okay, other parties shall not put an end to the contract because one party has already cancelled it. So B cannot put the contract to an end here. So these kind of questions are really very confusing. So you have to carefully read them and understand the situation. Everyone shall be permitted to take advantage of his own wrong. A legati means uh, who has been given something in a will. A legati was heavily drunk and driving his car at a speed of 100 km per hour in a crowded market. All of a sudden, his testator came on the road. There were other people on the road at that time. The car driven by Ligeti hit the testator and four other person. All the five person hit by the car and died. The legatee can take the benefit under the will. Legatee cannot take the benefit under the will. Legatee will be punished. The property of testator will go to his heirs. So, because the principle is everyone shall be permitted to take advantage of his wrong. So, if he has committed a wrong, okay, then legatee can take the benefit under the will is a correct answer here. Just to explain you a thing, a legatee is someone who is to be gifted something in the will, and testator is someone who has made the will that when I'll die, my property will go to legatee. Now, what he has done, he has caused an accident in which testator has died. Now he will become the owner of the property. Now we can see it in that way that in order to grab the property, he killed the testator early. Okay, but if we'll see the situation in this situation, it is a pure accident. So an accident testator is killed. So even though testator is killed at the hand of legatee, legatee can still take the benefit of the will. Everyone shall be permitted. Everyone is permitted to take the benefit, so he can take the benefit of his own wrong. Usually the principle is everyone no one can be permitted to take advantage of his wrong. But see, exams they can ask anything. So usually the principle is no one can be permitted to take advantage of his own wrong. Had this been the principle here, then also a legatee could have taken the benefit of the will. Because when we talk about the wrong, we talk about intentional wrong. Now this is a different type of wrong. Okay, he never intended to kill testator, but in a crowd somehow testator got killed. Even with the other principle, legati can take the benefit of the will. So that's it for the today's class. Thank you.